Here's your lordship's, your ladyship. We were on Connors and had established that the battle lines in that case were drawn around whether the discriminatory legislation was justifiable. In its general principles, at paragraphs 83 and 84, the Strasbourg Court said, at 83, the procedural safeguards available to the individual will be especially material in determining whether the respondent state has, when fixing the regulatory framework, remained within its margin of appreciation. And then at 84, the vulnerable position of gypsies as a minority means that some special consideration should be given to their needs and their different lifestyle, both in the relevant regulatory framework and in reaching decisions in particular cases. To this extent, there's thus a positive obligation imposed on contracting states. We note that there's no suggestion in the general principles that a full investigation of the factual merits must be undertaken in every case where possession is sought. Now, although the facts of the case were extreme, the Strasbourg Court approached the case by reference to the legislative framework in entirely general terms. And we see that at the final sentence of paragraph 85, which I think my Lord Hope specifically referred to yesterday. The central issue in this case is therefore whether, in the circumstances, the legal framework applicable to the occupation of pitches on local authority gypsy sites provided the applicant with sufficient procedural protection of his rights.
Can you just help me with this phrase, procedural protection or safeguards, because I don't find it all that easy. What is Strasbourg envisaging when it's calling for?
In my submission, what Strasbourg is envisaging in the general run of the cases, McCann, Kosic, Paulich, and so forth, is that there must be an opportunity before possession is ordered for the Article 8.2 proportionality question to be addressed by the court. That's the key procedural protection that is identified in all the later cases.
Is that what the last sentence of paragraph 83 is talking about as well? The decision-making process. Is that it? And then it's got to accommodate enough to be able to face up to the point that needs to be addressed.
I would submit yes. Now there's a wrinkle in the Connors case because of the way the argument went, which I'll come to, which is that if one looks at the way in which it went, first of all, the court went on after 85 to at 88 and 89 reject in terms the government's policy arguments. 88 halfway down, it's not apparent that it can be realistically claimed that the majority of local authority sites have to provide or aim to provide a regular turnover of vacancies to accommodate gypsies. The court isn't persuaded. The claimed flexibility is related to any substantial way to catering for an unspecified minority of gypsies, and so on. At 89, halfway down 89, notwithstanding the assertion that gypsy attitudes to authority would make court proceedings impractical, it may be noted that security of tenure protection covers privately run gypsy sites to which the same consideration could appear to apply. Consequently, the court is not persuaded there is any particular feature about local authority gypsy sites which would render their management unworkable, and so forth. So that's how the court reasons in relation to the matters put forward by the government, and then reaches its conclusion that the entire statutory scheme which permitted summary eviction of gypsies from local authority caravan sites was not justified. We see that at paragraph 94 in particular. Even allowing for a margin of appreciation which is to be afforded to the state, the court is not persuaded that the necessity for a statutory scheme which permitted the summary eviction of the applicant and his family has been sufficiently demonstrated by the government. The power to evict without the burden of giving reasons liable to be examined as to their merits by an independent tribunal has not been convincingly shown to respond to any specific goal or to provide any specific benefit to members of the gypsy community. However, we would submit that one has to read that second sentence in the context of what has gone before. What has gone before is that the court has been examining the statutory scheme which requires all others, in all other cases, except gypsies on local authority caravan sites, that the reasons must be given and must be examined on their merits by an independent tribunal. That's what the 1983 Act provides. Because the discrimination in that Act has been found to be not justifiable, it follows as a corollary of the unjustifiable discrimination that in this case, the gypsies on local authority caravan sites must too be allowed to have their cases and the reasons examined on their merits. What we submit would be wrong to take from Connors is that that establishes any general principle that in every case the procedural safeguard, to come back to my Lord Phillips's question, requires the giving of reasons liable to be examined on their merits by an independent tribunal. And as we will see in a moment, that phrase does not appear in the subsequent European jurisprudence. So that's all I wanted to say about Connors.
Can I just ask you about Connors then?
About,
Of course.
not merely about the second sentence of paragraph 94,
Yes.
which suggests that, as I think you recognise, that it's the statutory scheme must also be one under which an independent tribunal examines the facts on their merits. But you've tried to distinguish that. But just go back to paragraph 84. Isn't the first sentence saying what you reject as well? In other words, that there must be both the relevant regulatory framework and, under that framework, decisions in particular cases which give special, proportionate, no doubt, consideration to the needs and lifestyles of the persons involved.
Well, to that I would make 3 points. The first is that, in my submission, that must be read against the background of it being accepted generally in the regulatory framework that a full merits analysis will have to take place in relation to those ejected from caravan sites. And so that's the context in which this is being said. Second point I would make is that we fully accept that proportionality needs to be addressed in every case. What we don't accept, and where we differ from the appellants, we don't accept that that requires a full trial of the merits in every case before the county court. And the third point I would make is that paragraph 84 is specifically alluding to the vulnerable position of gypsies, which has been recognised in the Strasbourg jurisprudence. And for that reason, we would suggest that perhaps caution is needed in extrapolating too far from that particular sentence. Turning to McCann, which is the first of the trio of cases which we submit shows a consistent approach to the operation of Article 8 post-Connors, even where the statutory regime is not being directly challenged. That's in the same volume, volume 12, at tab 111. And as we know, the applicant, joint tenancy, which was terminated, leading to the tenancy to come to an end. We do say there was a significant point on the facts in that case, which hasn't yet been fully drawn out in this hearing. And we see that first at paragraph 11. Second sentence, on the same day a housing officer, having realised the property was not in fact empty, having taken legal advice, visited Mrs McCann and asked her to close the tenancy by signing a notice to quit. The county court judges who heard the local authorities' claim to possession found as a fact Mrs McCann was not advised and had no understanding that the notice to quit would have the effect of extinguishing the applicant's right to live in the house or exchange it for another local authority property. Approximately a week later, Mrs McCann wrote to the local authority seeking to withdraw the notice to quit, but it nonetheless remained effective. And the suggestion that perhaps there was a degree of lack of candour on the part of the local authority does run through the decision. If we go to paragraph 14, a third of the way down, we see that the county court judge, he noted the circumstances the circumstances in which Mrs. McCann had signed a notice to quit, and observed that if she had not been induced to sign it, the local authority would have had to apply for possession order under Section 84 of the Housing Act 1985. And then, if we move on to paragraph 43, there we see that that factual aspect of the case was the centrepiece of the applicant's submission to the Strasbourg court. The applicant maintained that the manner in which the notice to quit was obtained rendered his eviction an unjustified violation of his right to respect for his home. Article 8 was engaged because Mrs. McCann would not have served the notice to quit except at the request of the local authority housing officer. The local authority knew that the notice would have the effect of bringing the joint tenancy to an end without any opportunity for the applicant effectively to challenge the loss of his home. So it was the manner in which it was obtained.
It can't make a difference, can it? I mean, just suppose Mrs. McCann had loathed her husband and said, I'm going to make sure that he doesn't have any further right to stay in this property, and had entirely voluntarily served the notice of quit, and the local authority had nothing to do with it. Mr. McCann's position would be just the same. And surely he'd then be able to complain that the local authority should have recognised that it was monstrous that operation of law could deprive him of his home.
And isn't that clear from paragraph 55, that that's what the European Court thought too?
Well, I'll come to paragraph 55 in a moment, if I may. In answer to my Lord Mance's question, certainly in terms of the way the case was argued and in terms of the overall broad merits of the case might be seen, I would submit that there may be a difference by a local authority, as it was alleged, perhaps rather tricking Mrs. McCann into signing away rights on behalf of her husband unknowingly, and on the other hand, the ordinary case of a notice to quit being signed in circumstances where it's understood. There's a good reason why the law provides that a joint tenancy comes to an end when one of the joint tenants signs a notice to quit. That tenancy has been granted to two people jointly. It's typically, in this sort of scenario, a family home. In circumstances where the wife leaves with the children, it's by no means surprising or untoward that ordinarily the joint tenancy would come to an end, particularly where one is looking at scarce family social housing. So where I would, with respect, take issue with some of the points that were raised from the court earlier today is the suggestion that there is something inherently objectionable about a joint tenancy being brought to an end by one party unilaterally signing a notice to quit. It would be very easy for Parliament to legislate to say that where one party signs a notice to quit, the other joint tenant will succeed to a secure tenancy on their own. But Parliament's chosen not to do that. And we submit that in this well-trammelled area, as it's been put, or well-trodden area, as I think my Lady Hale put it in one of the previous cases, Parliament should have been taken to have thought about how the various rights pan out against the legislation. And so I would not, with respect, accede to that submission. Coming then to paragraph...
But the reason why there may be a justification for a landlord to be able to say, I granted a joint tenancy on the basis that two of you would be parties to this contract, and I want you both to remain parties to this contract, that is a way of looking at the situation. The way you've just put it is to do with the merits of the individual cases. And the complaint is that the merits of the individual cases can't be examined as the law stood.
But that brings me on...
Because after all, if the husband, the wicked, wicked husband, of course there are only a few of those, leaves his wife and children in the council house, of which they are joint tenants, and serves a notice to quit, that also brings the tenancy, the secure tenancy, to an end.
Yes.
On this. And of course the merits are completely the other way round from the way in which the example that you gave. As I say, the justification for it is a legal justification. It may or may not be correct. Some of us think that Hammersmith and Monk was possibly not necessarily entirely the best solution to the problem, but that's neither here nor there. All I'm getting at is the complaint here has to do with the merits and the proportionality of the people losing their home, nothing to do with the legal situation.
Well, I accept that, but in my submission, the solution to that does come from paragraph 55, which my Lord Neuberger referred to earlier, which is that the principle that we say that McCann establishes and has been followed and ought to be, with respect, followed by this court, is that whenever somebody is losing their home in circumstances where, under the general law, they do not have a right to security or to have the merits investigated, they should have the right to ask the court, which is being asked to make the possession order, to determine whether it would be proportionate in the circumstances of their case to actually make the possession order. And we say that's what paragraph 55 of McCann establishes. But in our submission, it's important not to take that too far, because what paragraph 55 talks about is the possibility of having the proportionality of the measure determined by an independent tribunal, i.e. the county court, or, for reasons we'll come to in some cases, the administrative court, saying, is it proportionate in all the circumstances of the case that this person should lose their home? What that doesn't require in our submission is further that in every case there should be a full-blown trial within the county court whenever the point is raised of the underlying merits of the local authority's decision, and that's where we do depart from the appellants. Just to finish on McCann.
Sorry, what does it require you to look at? Just summarise.
Well,
I mean, what's the distinction?
We would submit that what it requires is that the court look at the circumstances of the individual, weigh that against the fact that Parliament has decided that they have no right to remain and that the local authority has an absolute right to the property and is responsible for the allocation of social housing to others, and weighing up that very weighty matter against the individual circumstances of the occupier, would it be disproportionate within the Article 8.2 question for them to be evicted?
So how does the court determine the circumstances of the individual?
Those must be determined by a factual inquiry. That I accept. And therefore it may be necessary, for example, for medical evidence to be listened to by the court and matters of that sort. But what we don't accept, for reasons which I will develop, is that in addition, in circumstances where Parliament has said a local authority doesn't need to establish particular reasons before the court, in addition, nonetheless, the county court should excavate the local authority's justification in the way they would in a secure tenancy case. That, in our submission, is taking it too far, collapsing the distinction between secure and non-secure tenancies and driving a coach and horses through the legislation.
But I mean, say the tenant's been there for 20 years and there it is, he's in not very good health. I mean, are the local authority, are they allowed to say, but we have a very particular need for this, we want to develop the block or whatever it may be. I mean, are they allowed to widen the ambit of the inquiry as to whether it'll be more proportionate?
Well, to be clear, our submission would be the fact that the tenant is old and not in good health would not ordinarily be sufficient to render it disproportionate to order possession when the local authority has an absolute right to the property.
But we may be getting ahead of in the argument, but that dreaded word ordinarily means that everybody is going to run the argument and the court's going to have to look at the argument in every case.
Well,
at a time when the courts are trying to become more efficient and streamlined,
yes,
the effect of this is going to boost precisely the opposite result. the possession list is going to be almost a thing of the past. The judge is going to have to look at the facts of each case in order to decide whether there is the possibility of an Article 8 argument.
Well, there's 2 points on that. First of all, the Strasbourg authorities, as we shall see, make it quite clear that the judge doesn't have to look at it in each case. It's for the occupier to raise the point.
Well, once he or she's raised it, the court's going to have to look at it. So that's
the second point is, notwithstanding the concern that's been raised by various members of the court about defining or giving guidelines as to exceptionality, we would invite the court to both give examples of what are and are not exceptional cases, and in due course I will be providing some proposals in that regard.
In writing?
Orally, they can certainly be provided in. Well, the exceptional circumstances we see would apply are in writing at paragraph 33 of our case.
I'm conscious of those, but these paradigm instances
Yes.
of where they would and wouldn't work would be helpful to have in writing.
Yes. Well, overnight, I'm sure we can also provide some of the cases we would say would be not.
At the moment, I think the authoritative domestic statement is the second sentence of paragraph 110 in K, which is, do not look at individual circumstances at all. You don't support that, do you?
We don't support that because we submit that can't stand with the recent line of Strasbourg authorities.
Well, that's why in Doherty it went further, and in fact in paragraph 55, which I have in front of me, what can be examined is the aim the counsel are pursuing and the length of time in that particular case the defendant and his family has resided on the site. So there's an element of fact brought in there.
There is, and certainly we would accept that in Doherty the domestic jurisprudence has converged somewhat with the Strasbourg approach. Our submission is, however, that even paragraph 55 of Doherty doesn't go far enough, because what it doesn't allow for is an examination, a factual examination, as at the date when the matter comes before the court of the individual circumstances.
But, I mean, the one thing that you don't allow examination of looking at your case is, and as I think you just said, the local authority's reasons or the strength, therefore presumably the strength of its case for seeking possession.
Yes.
It must be a source for the goose and gander. If the local authorities' reasons in that sense can't be challenged, they can't be a positive factor either. No. So every case you just approach on the basis the local authority has a need or has a right in law, and then the only thing you can set on the other side is personal circumstances in terms of health and that sort of thing.
Health, well-being,
you can't, I think your case has made very clear, look at the local authorities' reasons in relation to these tenants, the personal circumstances of these tenants, whether they're a nuisance and so on.
No.
I mean, where do you get these dividing lines from?
The reason is twofold. One gets it from the legislation, because the legislation ex hypothesi is legislation which says a local authority doesn't need to establish reasons in order to get possession. So it's a demoted tenancy case, an introductory tenancy case, a temporary homelessness accommodation case. Obviously, if we were in secure tenancy regime, then they would have to do that. But here, Parliament has decided they don't need to do that. Parliament having decided that, in my submission, one can't give sufficient deference and effect to Parliament's will without acknowledging that that can't be excavated in the context of the proportionality hearing.
But that's a non sequitur, isn't it? The fact that they don't have to rely on it to justify the right to possession can't mean that if they got a terribly strong case, that they can't rely on it to meet the apparently fairly strong Article 8 case that the tenant runs. That would be extraordinary.
Well, in my submission, the way it would work would be this: that the local authority can put forward its reasons. If the tenant says, or the occupier says, well, I didn't engage in nuisance, or it's mistaken identity, or the antisocial act you accuse me of wasn't as serious as you say it is. There's no way of addressing that issue without completely doing away with the important distinctions that are drawn in the legislation. We can see it at section 143D of the Housing Act 1985, if we can turn that up in volume 2. Tab 10. Parliament has decided that in a demoted tenancy scheme, and I stress that the provisions in relation to introductory tenancies are virtually identical and much more numerous. In subparagraph 2, the court must make an order for possession unless it thinks that the procedure under sections 143E and 143F has not been followed. So what Parliament has decided is that it's not for the county court to look at the substance of the reasons put forward by the local authority in a demoted tenancy case. And in our submission, the appellant's submission, that one can look at those reasons and scrutinise them simply cannot stand with the legislation.
But you might as well say if the tenant insists on a review under section 143E and following and puts forward all sorts of arguments, he can't rely on those arguments either, because section 143D says the court must make an order. It applies to both sides, surely.
Well, yes. And so all the court must assume that the local authority has an absolute right to the property, just as it would, for example, in a case which fell wholly outside the statutory scheme for one of the various reasons referred to in Mr. Arden's case, where one just says this is a case where the occupier has no rights. Now, taking that as the position, starting position, looking at the circumstances, would it be a disproportionate interference, given the extremely poor health or whatever of this tenant, or occupier rather, to make the order for possession? And my submission, that's a perfectly workable and appropriate question to ask, and is in line with the Strasbourg jurisprudence, and provides a way through the two alternatives, which is either the status quo, which doesn't keep up with Strasbourg, or the appellant's approach, which simply does away with the important distinctions that Parliament has made in this area.
I'm not sure that paragraph 55 of Doherty, I'm sorry to keep coming back to this, is in line with what you're submitting, because it does say that an examination of the question whether the Council's decision was reasonable, having regard to the aim which it was pursuing. Now, it's assuming that it has an absolute right to repossession, but nevertheless it's doing so for a reason. It may be because of the housing stock or whatever else it might be. But it seems to recognise that one can look at the two sides of the equation, as Lord Neuberger has been suggesting. You look at the particular circumstances that are raised about the individual length of time in that case, and the Council's reasons, and balance the two against the other, or each against the other.
Well, as I indicated earlier, it seems to me that does go quite a long way towards it. Where I would submit that it doesn't go all the way is in relation to the following two sentences.
I can't see that, but as far as it goes, it does look as though it's more generous than your submission.
Yes, as far as it goes further than it needs, is your submission.
Yes. You see, the point that we're getting at, as I understand it, is that the Council may have more than one legitimate aim in seeking to repossess this property. One of the legitimate aims may simply be that it has a better use for the property than allowing the current tenants to remain there. Another may be that it wishes to protect the neighbouring people living nearby, both of which might apply in a case like this. Because after all, if it's a family home that's brought up 5 sons, and now they've all left home, or most of them have left home, maybe there are other reasons for pursuing it. This happens to be the circumstances they can. But you can't evaluate whether that legitimate aim is rationally achieved by the step the Council is taking, or whether it's proportionate the step is proportionate to that legitimate aim and to the harm that it will do, without actually looking into the strength of the legitimate aim, which is, I think, the point that Lord Hope was
I think
making.
on reflection, I think I would accept that it is appropriate for the court examining this to look, as it would, for example, in a judicial review case, to look at the reasons relied upon by the local authority in seeking possession, and therefore there would be a distinction. For example, a case which was based purely on an arbitrary whim on the one hand, and a case that was based on sound and weighty reasons on the other.
But there are distinction here between the reasons they're entitled to rely on to justify their claim, for instance, nuisance in this case, and the wider sort of reasons that Lady Hales identified, which would be perfectly proper for them to put in the balance, it seems to me, on the Article 8 argument, but not as a ground for justifying the notice.
That's right.
Yes.
Right.
Well, as I say, I would accept that the underlying reasons and the seriousness of their basis for seeking possession is a proper matter to be taken into account, as it would be in the ordinary public law sphere. Where I would submit this formulation doesn't sit so easily with the Strasbourg jurisprudence, if I may say so, is that this is looking at the issue through a classic domestic public law lens. And for a number of reasons in my submission, that is an importantly different exercise from the proportionality exercise. And in particular, I'd emphasise the following three features.
I think you're right about that, because one was constrained by Kay.
Yes.
And you're quite right to make that criticism. But sorry, you're saying
No,
there are three things.
plainly the House was constrained by Kay. The three features that it seems to me are different. First of all, that conventional public law is focused on the decision-making process of a public body and the lawfulness of the decision-making process. Secondly, traditional public law is focusing on the facts as they were known at the time when a public body took a prior decision. And the third distinguishing feature is that in conventional public law, one is using concepts such as unreasonableness or irrationality rather than proportionality or necessity. Now, on our reading of the Strasbourg cases and the proportionality requirement that they now have established, one is not looking at the decision-making process, one's looking at the substance as at the date the matter becomes before the court. In terms of timing, one's not looking at the matter historically. One is looking at, again, as at the day when the matter comes before the court. And in relation to the test to be applied, one isn't applying a test of unreasonableness or irrationality, however that may be amended or expanded. One is asking the simple Article 8.2 question: is it proportionate in all the circumstances in the sense of being necessary to achieve legitimate aim? And so our submission would be, although of course we fully understand why in Doherty there was no alternative but to seek to work within the Gateway B approach that had been developed in K, with a panel of 9, we would submit it's open to this court not to seek to put the square peg of proportionality within the round hole of conventional judicial review, but simply to accept, in line with McCann, Kosich and Paulich, that Strasbourg law now does require that at the very end of the process, it must be open to the individual occupant to say, well, I have no right to be here, but in all the circumstances, it would be a disproportionate interference with my rights for me to be evicted. And on that basis, I ask that no order for possession be made.
So in that situation, it's the order that what you're considering is you're focusing on the decision of the court to order the eviction. Is that right?
That's right. And ultimately, at that stage, it is the decision of the court which is important. That is the procedural safeguard. However, I wouldn't wish to be understood from saying that to be submitting that the local authority isn't bound to comply with Article 8 when it takes decisions earlier in the process. Far from it. The local authority is a public authority subject to Section 6.1 of the Human Rights Act, and our submission would be that in taking any decisions which affect others' rights, it should comply with Article 8 of the Human Rights Act. However, the Lord is quite right to say that when one looks at the Strasbourg jurisprudence, that's focusing on the court at the final stage, asking for itself the Article 8 question as matters stand on that day.
And how does the court gain its entitlement to do that? I mean, do you following Mr. Drabbles' approach on that?
Is that on Article 6.2? So Section
Well, on
6.2b.
7.2b, absolutely.
Section 6.2b. We do. Our
No, well,
7.2b.
7.2b not defeated by 6.2b.
Well, Section 7.1b entitles the occupant to raise the point. Perhaps we should have the Act in front of us.
Yeah. 7.1b is our enough.
Yeah.
But I mean,
So Section 7.1b entitles the occupant to rely on his Article 8 right before the court.
Well, which is the public authority,
Yeah.
you say, has acted in a way which makes it unlawful, so he can rely on it. 7.1b, he can only rely if a public authority has acted in a way which is unlawful.
I don't think 7.1 can be said to be invoked for all the world as if the court is the public authority.
No, to be clear, we would say that the occupant would say, this local authority is breaching my Article 8 rights by seeking possession against me. So,
Yes, so that's Mr. Drabbles' route.
Yes.
So you are, I mean, you're taking his route to it.
Yes.
Because otherwise, I mean, the court on the face of it hasn't got a way in, has it?
What about Section 3.1?
3.1 of the Act.
Well,
Is it possible to read that to read 143D2?
no, we would submit not.
Otherwise, you could read every section of every act.
Yeah.
This is
On
the
that
validly
basis.
point. This is Mr. Drabbles' validly point, isn't it?
Yeah, well, lawfully point, I think. he
Lawfully,
calls it.
sorry.
Yeah, he calls it his lawfully point. But in my submission, it would just so plainly be contrary to what Parliament intended that Section 3.1 wouldn't suffice.
So actually, even the lawfully point only goes to the public authority's action, doesn't it? I think.
I think that would be right. And also, as Mr. Hoover points out to me, one doesn't need Section 3.1 because we submit that one can get to a convention-compatible result through an alternative route.
Well, yes, but this is if you can't.
Yes, well, if we can't, then one would ultimately be driven into, we would say, a declaration of incompatibility.
So you say that by deciding to bring possession proceedings in circumstances where the court would have no alternative but to make an order for possession, the local authority would be in breach of its duty, or in breach of the Article 8 rights
Yes,
of the occupier,
yes.
imposed by what? Why is the local authority, why does it have Article 8 responsibilities
Because of Section
if Parliament has said it's a matter for the courts?
Because-
I beg your pardon, if the Strasbourg says it's a matter for the courts to decide.
Well, because first, the local authority is a public authority within Section 6.1 of the Human Rights Act, and so must always act compatibly with convention rights. And secondly, although the formulation used by Strasbourg is that there must be a procedural protection by way of an independent court determining the proportionality issue, in my submission that doesn't imply that the local authority is in any way itself exempt from acting compatibly with Article 8. So we would say that there's no inconsistency there at all.
The local authority, you would say, is under a continuing duty. Is it under Section 6.1? I mean, there's the initial decision to bring the proceedings, the NPP or whatever it's called, to bring the matter before the court. But then it maintains that position, doesn't it?
Yes.
Right up to the point at which it actually asks the court to pronounce the order. So you can say it's a continuing duty, and indeed, if it's disproportionate, a continuing breach. Right
I would
up
certainly
until
accept
that
that if circumstances change or if new facts emerge, and it maintains a position that is disproportionate and would be in breach of Article 8 rights, then that's something that it's not lawfully entitled to do by virtue of Section 6.1.
It can probably be put much wider than that, can't it? I mean, Strasbourg keeps saying that taking someone's home away from him is the most drastic interference with Article 8, but a big local authority which has a big housing stock has got all sorts of other ways in which it's got to look after its tenants' Article 8 rights by seeing that the sanitation is kept and the drains and the dam. I mean, all that probably comes within the ambit of Article 8, doesn't it?
Yes, Mr. Lord, there are many ways in which a local authority could violate Article 8.
Other than by taking proceedings for possession.
Certainly, for example, by unlawfully surveilling the people in its premises or whatever. So certainly that it is much wider than that.
Can I just ask?
Yes.
How much water is your finger in the dike stopping now? If you just turn to paragraph 31.2 in your case. In the last 8 or so lines, you are at pains, or in fact the whole of this paragraph, you're at pains to say that a merits review of the underlying reasons for seeking possession would plainly not be capable of being conducted. Some, in the great majority of cases, occupers would in all likelihood frequently dispute allegations that they'd, for example, engaged in antisocial behaviour or breached the terms. And you're saying none of that can take place. But am I right that you've now abandoned all that? You now accept that on reflection, a court examining the public authority's decision to look at the reasons relied on in seeking possession could examine, I've just wrote down what you said, the particular reasons relating to the tenant's behaviour. So all that goes.
Well, no, it doesn't go. What I would say it can look at is the, as it were, the nature of the reasons put forward by the local authority. So, for example, at one extreme, one would have a local authority simply putting forward no positive reason at all for doing so. At the other end of the spectrum, the local authority may have important health and safety reasons to need to vacate the properties, and there'd be very good reasons.
Wait a minute. Now, I thought that was the one thing you said couldn't be examined. Are you also abandoning 31.1 there at the top of the page?
Well,
because that's where you say you can't look at you must take for granted the local authority's right and presumably general need for the flat.
Well, initially I did say, and this is where I step back from what I'm saying, initially I suggested one simply ignores the reasons altogether. That on reflection, it can't be right. The way I would put it is that the local authority can choose what its legitimate aims are in seeking the property. And in my submission, looking at its legitimate aims is a key part of the Article 8.2 Balancing Act. So if it is something very weighty and so forth, that's to be taken into account. If it's something very minor, that's equally to be taken into account. Where I stand by paragraph 31.2 of our case is in saying the one thing one can't do is get into a trial on the facts of the specific allegations or matters that are relied upon in, for example, a nuisance case, where to do so would be to wholly circumvent the statutory scheme. And so we do draw a distinction. It's really a distinction between looking at the local authority's legitimate aims on the one hand, which we would say is permissible, and on the other hand, a full trial of the merits of any matter that's disputed by the claimant as to the reasons, or rather the occupant's reasons, which we say would not be.
Supposing that the occupant does dispute the point upon which the local authority relies, what happens?
Well, I suppose the analogy here in this context would be with the way one approaches public law judicial review cases. So if one was looking at an ordinary public law challenge, one could have, for example, an occupant saying, you say your legitimate aim in doing this is because you want to manage your housing stock differently. I say you're saying that in bad faith and you're lying to the court, and that's not the reason. Now, that kind of challenge conceivably could be brought. Where I think one couldn't go is if the local authority is saying, well, in our judgment, we think this antisocial behaviour has gone on too long and it's too serious. And in that case, if the occupier is saying, well, it's not that serious, in any event, I didn't do it, that's not the sort of debate one would have, for example, on an ordinary judicial review challenge, and we would submit is not the kind that one would have in looking at legitimate aims and proportionality on an Article 8.2 type procedure.
What's judicial review got to do with it? I mean, the whole point that
No,
we have from the European cases is it's no good because you can't have the factual.
I'm drawing an analogy there because where I would submit what one can go is to look at the legitimate aims, and indeed one has to under Article 8.2. Yeah. What one can't do, in my submission, because it goes against the statutory scheme, is to simply have a complete trial where everything's up for grabs and all the underlying factual matters are up for grabs. And that's how it would be in a judicial review. In my submission, there's nothing inappropriate or surprising in that being the approach that the court would take in looking at proportionality. However, in looking at proportionality, one would have to look factually at the up-to-date circumstances of the occupier.
Can we draw a distinction here? We are here talking about cases in which, by definition, the landlord public authority has domestically a complete right to possession. So the one thing that this exercise is not about is about the history that gave the local authority that right to possession.
Yeah,
would you agree with that?
Yes.
So that going back over the past that led to the demotion order, or in other circumstances, going back over the past that led to a possession order, a suspended possession order, or even an absolute possession order that the local authority chose not to execute, because actually those are all comparable situations.
Yeah.
That sort of factual inquiry would not be in the slightest bit appropriate, would it?
No.
What we're looking at here is an allegedly exceptional case when there is an argument about the proportionality of exercising your absolute rights.
Yes.
And so all we're looking at is what they say their aim is in exercising those absolute rights and how the circumstances of this case connect with that aim.
Yes.
That's the scope of the inquiry.
That's the scope of the inquiry.
Does that make sense?
Against the background of the absolute right always being a very weighty matter, which will weigh in the background.
Is it correct to say that under a demoted tenancy, a local authority has an absolute right to possession? I would have thought unless and until the local authority gives a notice, the tenant has an absolute right.
Once it's gone through all those stages.
But I mean, therefore, you're immediately faced with a public authority decision which, on the face of it, has to be justified as proportionate.
But of course, it's served the notice for a particular reason, and you take its reason at face value. Is that what you're saying? You don't.
Yeah.
It simply puts on the table its reason.
Yes.
And the strength or otherwise of that reason as against the countervailing factors is something for the court to assess.
Yes. Although the major point in every case will be the fact that if it's gone through all the procedures which it has to, which are purely procedural requirements, if it's gone through those, then it will have an absolute right to the property, and that will be the weightiest factor.
Yes,
One then weighs in the reason it puts forward the legitimate aim, balances against that any exceptional circumstances or particular personal circumstances that the occupier can put forward.
They've put forward the reason. The tenant has said, no, it's been reviewed, and they've upheld it, but he still says no. He says it's not true, it actually didn't happen.
Well, in my submission, the tenant can't take the point any further at the stage of the long stop proportionality review that we put forward.
He could do so in Connors. That was one of the points in Connors. But you said, I think, earlier today that was a different point because it was a discrimination as against those who had rights in the same kind of area but were allowed to challenge the reasons under the statute.
Precisely. Under Connors, had there not been this specific discriminatory exclusion, the applicant would have had the opportunity for a full merits trial because he was a secure licensee, as it were, in that case. But that was the Connors case, and that was the specific context of that.
So even though the court thinks that if it didn't actually happen, it would be disproportionate to make the order, it nonetheless can't look into that matter.
Precisely, because the Parliament has specifically said the court can't look into this. That's what Section 143D says.
But is that Article 8 compliant? If Strasbourg has said you've got to look into all the facts to see if it's proportionate?
Well, yes, because I'm coming to, I hope...
Independent tribunal has to look into it.
Well, I'm coming, I hope, to the Strasbourg cases from McCann onwards, because what one sees there is an acceptance in the Strasbourg jurisprudence that the domestic legislative framework can be one which permits the individual no way to challenge or to argue against their occupation. All that Strasbourg then says, if one looks at McCann, Horlich and Cossage, is that, however, you do still have to allow them finally to ask that Article 8.2 proportionality question, but that's a very different thing from the Connors type case where you have to have a full review on the merits. And if we can perhaps look at those cases, we were on McCann, which is at volume 12, tab 111. Key paragraph, first is paragraph 50, second half of paragraph 50, page 9 to 8. Any person at risk of an interference of this magnitude should in principle be able to have the proportionality of the measure determined by an independent tribunal in the light of the relevant principles under Article 8 of the Convention, notwithstanding that under domestic law his right of occupation has come to an end. And the focus is on simply having the proportionality of the measure determined. And then at 54, the court does not accept that the grant of the right to the occupier to raise an issue under Article 8 would have serious consequences for the functioning of the system or for the domestic law of landlord and tenant. The minority in the House of Lords in K observed it would be only in very exceptional cases that an applicant would succeed in raising an arguable case, which would require a court to examine the issue. The great majority of cases, in order for possession to continue to be made in summary proceedings. And I would respectively observe that the European Court of Human Rights is there putting the long stop Article 8 defence, as I would put it, in rather minimal terms. It's simply saying, in principle, it should be able to have the proportionality of the measure determined, that the domestic law of landlord and tenant should not be disrupted, and that it's in very exceptional cases only that this sort of long stop Article 8 defence would succeed. And in my submission, that's simply inconsistent with the suggestion that the occupier should simply be able to reopen every issue that may have gone before in raising the Article 8 challenge. And we see the same formulation in Cossage, which is in the same volume at tab 107. That's the teacher who occupied a flat, but the lease expired and was not renewed, and the municipal court granted possession. As in McCann, the European Court of Human Rights found no general difficulty with the limitations of the domestic law, but held that the domestic court should have gone on to consider the proportionality question. We see that at paragraph 21. In the present case, the court notes that when it comes to the decisions of the domestic authorities, Their findings were limited to the conclusion that under applicable national laws, the applicant had no legal entitlement to occupy the flat. First instance court expressly stated that whilst it recognised the applicant's difficult position, its decision had to be based exclusively on the applicable laws. The national courts thus confined themselves to finding that occupation by the applicant was without legal basis, but made no further analysis as to the proportionality of the measure to be applied against the applicant. And then at 22, 3 lines down, any person at risk of an interference of this magnitude should in principle be able to have the proportionality and reasonableness of the measure determined by an independent tribunal, notwithstanding that under domestic law his or her right of occupation has come to an end. See McCann. So again, the domestic law stands, and there's nothing wrong with that, excluding security of tenure and so forth, but in principle having a long stop proportionality defence is required. And we see that finally in Corliss.
What do you mean by the long stop there?
Well, long stop,
Did you get the long stop there?
No, those are our words, of course, my lord. But in my submission, it's quite telling, the distinction between the formulation in, for example, the Connors case, where it talks an examination of the merits by an independent tribunal, which would be a trial of the kind that the appellants would have apply in this sort of case, and the rather more limited formulation in this case, which is talking about, in principle, having a right to challenge the proportionality of the measure, notwithstanding it's accepted.
Proportionality and reasonableness.
In this case, they add the word reasonableness. That's
What do you say the measure means?
The measure is eviction.
Yes.
Yes.
It's what? Sorry, is that what?
Eviction.
Eviction.
So what's the difference
Between
that and the Connors formulation?
the Connors formulation is that the individual has to have a full trial on the merits of the justification put forward in their individual case for seeking possession. That's the distinction. And we see...
it's the measure to be applied against the applicant. It's surely involves looking at how does this evicting this person, is that proportional?
Yes, of course, and that's why one has to look at their circumstances and weigh them up against the fact that under domestic law they have no right to be there, and that the local authority ex hypothesi has a legitimate aim in seeking it. One does, of course, look at their individual circumstances. One doesn't go to the Connors stage and say, and also you have to have a full trial of the specific reasons which may be relied upon with live evidence, cross-examination and all the rest of it. That's clearly not what the European Court has in mind in this formulation, in our submission. And we see that too from Paulich, if we could go there in volume...
Just before you do
Yes.
that, I mean, it's to say Connors is to be distinguished from McCann is I have little difficulty with. If you look at paragraph 50 of McCann,
Exactly right.
it seems to me that they're equating the two. I'm sorry to cut across here.
No, of course.
Is this paragraph 50?
Paragraph 50 of McCann.
It uses the word measure.
Yes.
Also.
Oh, yes, I noticed that. Yes, it does.
Yes, but what they've done there is they've set out the general principles in McCann, the general principles in Connors, 81 to 83, which I took your lordship's ladyship to 83 earlier, none of which contain the suggestion that there has to be a merits review in every case. It's only on the peculiar facts of McCann in paragraph 94 that one gets that formulation. That is not endorsed in McCann, nor in Cosich.
Paragraph which four in Connors?
94 in
In
Connors
McCann?
is the only one.
In Connors.
Yes.
Sorry.
And it's a phrase there, the burden of giving reasons liable to be examined as to their merits by an independent tribunal, which is right in the middle of that paragraph that you say isn't repeated in 50 of McCann or 21 of Cosich.
Those words are striking by their absence from all of the other cases.
Yeah.
It's only Connors that has that formulation, and that's because Connors was a very different case where, but for the discrimination, that's what Mr. Connors would have been entitled to.
So it's
Basically, you're saying that paragraph 94 is actually looking at the justification of the particular statutory scheme.
Yes. What they refer to
Sentence number 1.
in 84 they refer to as a relevant regulatory framework. So it was a framework for other people.
Yes.
And to be fair, they ought to be brought within the same framework, really.
Yes.
I mean, are you saying that in Connors, article for purposes when one's thinking about discrimination and so on, that it certainly was within the field of Article 8. But are you saying that it wouldn't have involved a breach of Article 8?
In Connors?
Yeah.
No, it did.
Yeah.
And that's because the legislation itself was found to be incompatible with Article 8.
But
Yes, but the reason is that it doesn't provide for individual examination on the merits by an individual tribunal of the decision process leading to measures of interference.
Yes, in circumstances where everybody else has that right.
Why does that matter?
Because here you have a scheme where everybody is a secure licensee, as it was in this case. One category of person has been excluded, and they say it is disproportionate under Article 8 to exclude that category. The corollary, the consequence of them being included would be that would be the right they would have. But what Connors is not saying is that is a universal requirement of Article 8 in all circumstances.
I see that approach to Connors. Indeed, I think I made very plain in K that that's how I read it. But the difficulty, as my Lord says, is in the first sentence of paragraph 50 of McCann. McCann is post-K, and I'm not sure post-K whether I could have written what I wrote, because it says in the first sentence of 50 that they don't buy the UK's argument that Connors is confined only to gypsies. All cases where the applicant sought to challenge the law itself rather than its application of the particular case, that's the trouble. I mean, I like this dichotomy of yours, and you spell it out in your printed case very attractively in paragraphs. Page 18, two types of Article 8 challenge, and there's the sort of Connors type, and then the McCann type. Where do we get it?
Well, what I would submit is that one has to be slightly careful about how one reads decisions of the European Court of Human Rights. They don't have, well, with respect, they don't have the same close reasoning as decisions of the domestic courts, and there are some use of boilerplate language involved, and a certain looseness, and one has to stand back a little bit and look at them. In my submission, there's no difficulty with paragraph 50, because first of all, if you look at what's being quoted from Connors, there one is quoting very general principles which are entirely consistent with the approach in McCann and do not contain the formulation that appears at the end of Connors, point 1. Point 2 is that in the first paragraph, the first part of paragraph 50, the European Court is addressing a specific argument that was raised by the government in McCann, unsuccessfully, that Connors should be seen as entirely sui generis because it dealt with positive obligations owed towards gypsies.
But then there's the or, an ultimate word of line 2.
Yes. Well, in my submission, it would be putting far too much weight on that sentence in that context to see that as generalising the conclusion at paragraph 1.
What you are entitled to say is that by the time you get to paragraph 54 of McCann, here's the court saying, you can do all this in summary proceedings.
Yeah. Well, that in my submission, that explains our argument and is why only our argument really fits the authorities of the various arguments you have before you. Because only if we are right about this being, as we describe it, a long-stop review where you have a final check, is this overall a proportionate measure? Is it realistic for the Strasbourg court to say and adopt from Lord Bingham in K that it would only be very exceptional you can do this, and you can do it in summary proceedings? And no one else's analysis in my submission is able to explain that.
In this particular case, what matters do you say Mr. Pinnock would be able to bring forward at the long stop stage?
Well, he would be able to bring forward any personal circumstances that he wished to, so including, and I don't know the details of his case, but if there were serious ill health issues, if there were serious issues about local ties, if there were the fact that he'd been there for 30 years, those are the kinds of things one would imagine he would put forward. However, I would emphasise that none of those matters are likely to get anywhere near
No, he wouldn't be able to bring forward the point that his sons hadn't done what they...
No.
What about the point that his sons didn't live there and it wouldn't have any effect on neighbours?
Well, in my submission, not, because that again is going into the contested area that was the subject of the local authority's decision, which Parliament has decided is for the review process, was dealt with in the review process, to incorporate those in the matters that were subject of the internal review, which Parliament said should not be determined by the court, to incorporate those subsequently in the court proceedings would be going behind the statutory scheme.
But if he wanted to say that his sons had recently discovered religion and were now reformed characters, and that had happened since the review, he'd presumably be entitled to do that.
Yes. If I can turn then to Pauline, that's in volume 13, tab 115. This was the case of another case arising out of the estate of the Yugoslavian National Army, where the claimant was a civilian employee who again failed to obtain security of tenure and indeed failed to obtain a specially protected tenancy at all. And again, as in McCann and in Kosic, the European Court of Human Rights held that there was a requirement to go beyond the domestic law and ask the proportionality question. You see that at 42, paragraph 42, the court notes that when it comes to decisions of domestic authorities in the present case, their findings were restricted to the conclusion that under applicable national laws, the applicant had no legal entitlement to occupy the flat. The national courts thus confined themselves to finding occupation by the applicant was without legal basis, but made no further analysis as to the proportionality of the measure to be applied against the applicant, namely his eviction from a state-owned flat. However, the guarantees of the Convention require that the interference with an applicant's rights to respect for the home is not only based on the law, but proportionate under paragraph 2 of Article 8. And so that's the way they approach it. And they go on at paragraph 43 to reiterate the McCann approach. In this connection, the court reiterates that any person at risk of an interference with his right to home should in principle be able to have the proportionality and reasonableness of the measure determined by an independent tribunal in the light of the relevant principles under Article 8. Notwithstanding that, and this is accepted under domestic law, he has no right to occupy a flat, see McCann. The court, however, emphasises that such an issue does not arise automatically in each case concerning an eviction dispute. If an applicant raised an Article 8 defence to prevent eviction, it's for him to do so and the opponent to rebut the claims. Previous help, of course, does not accept that the grant of the right of an occupier to raise an Article 8, an issue under Article 8, would have serious consequences for the functioning of the domestic systems or for the domestic law of landlord and tenant. And so we submit one sees there again the European Court being extremely circumspect about the scope of the proportionality view which it has in mind. It's not using the Connors type formulation, it's using the McCann formulation, which simply requires that at the very end of the process, the occupier should be entitled to say, well, I know I've got no right to be here, but it would be a disproportionate interference with my rights for you to evict me, please don't. And in my submission,
it goes back not only to 54, but also to 28, and that's Lord Bingham's speech, page 923 of McCann, where I must say it was a very optimistic view, but I mean, there it is. The court would be entitled, on Strasbourg's approach, to be pretty ruthless.
yes, and what, in a sense, what McCann and the cases that follow it do, we say, is adopt the minority in K.
Yes, and Lord Bingham said it would be unlikely to have any serious effect. But, I mean, with all due respect, we've got to examine that a bit critically. Strasbourg, understandably, have taken that to be the case. But in practice, you get a possession list. The tenant turns up. Often, presumably, will often be told by citizens' advice or personal support unit or somebody in court, you can run Article 8. In practice, most tenants, I would have thought, who turn up will have a go at doing that.
Yeah, and the tenant says, I've been there for 20 years and I've got poor health. And the county court judge says, well, that's not going to get you anywhere.
Well, the tenant may say, look, I've been told I've got an Article 8 opportunity, I want to consult a lawyer. I mean, it will play havoc.
But one can see how procedural spanners can be put in the works in any proceedings. But if this court is prepared to lay down some guidance, in my submission, Lord Bingham's prediction may yet prove to be not wholly unrealistic.
No. I mean, clearly, if it does apply, if we can properly give assistance rather than confuse matters, rather than help matters, which is sometimes what happens when one tries to give assistance, I accept for my part that we should.
Yes.
If we can helpfully do it.
So that really brings me on to the next point that I was going to raise, having just noted, for your note, and I don't ask the court to go there, that in my submission, everything that I've quoted from the Strasbourg jurisprudence and submitted to your lordships, your ladyship, is entirely consistent with what Lord Bingham said at paragraphs 29 and 39 in K. But moving on to this question of exceptionality, in my submission, it's not unduly optimistic to regard the approach of Lord Bingham and Strasbourg and McCann and the cases that followed it as workable for this reason. First of all, and we say this will always be the most weighty factor, ex hypothesi, the occupant in every case which will fall within this analysis will have no right in domestic law to remain. In circumstances where, subject to an unusual case like Connor's, the domestic law will itself be convention compliant. So the local authority's absolute right to possession of its property will weigh very heavily in the Article 2 balancing exercise because Parliament has decided that it should have that right. And the local authority's property rights will weigh all the heavier in our submission, given that it has been charged by Parliament with allocating and managing scarce social housing stock, which may be needed to protect the Article 8 rights of others. And that factor alone, we submit, will almost always provide an overwhelming answer to the Article 8.2 question. And that factor was specifically referred to, and again, I don't ask the court to go there, but by Lord Bingham in K at paragraphs 33 and 35, and by my Lady Baroness Hale in K at paragraph 180. The further point...
Isn't it circular to assume that the law is convention compliant?
Well...
I mean, the whole question we're asked to consider is whether it is convention compliant to have a system which introduces a tenancy, a demoted tenancy. That thus far it's clearly convention compliant. There's a full judicial review, but then enables the demoted tenancy to be removed without a full proportionality review. And to assert that that is convention compliant is to assert what you've got to prove.
Well, I work on the basis that until convention incompatibility has been established, it should be assumed. Now, in McCann, there was no suggestion of lack of compliance. As I understand the appellant's argument in this case, their primary argument is that the legislation here is convention compliant. And in my submission, it plainly is.
Yes, but you don't. They only make that primary argument on the basis that you can have a full review of the local authority's decision, where it is exactly what you don't accept.
Well, Mr. Drabble was very careful not to take the Article 6 point, I think, and say that it was not compliant on that ground.
Yes.
He says he doesn't need to say that.
No.
But I suppose it's a sort of fallback if he needed it, but he didn't have to develop it.
Well, my submission is that on our analysis, this legislation is convention compliant, and that no argument's been raised against us to suggest seriously that it isn't.
To just make my position clear, This scheme is convention compliant, provided there is a realistic prospect of the court examining the legality of the actions of the panel and subsequent actions of the local authority in terms of Section 6.1. If the effect of my learned friend's argument is that the legality of those actions in Section 6.1 of the Human Rights Act cannot be examined, then the scheme is not convention compliant.
And that's because of Article 6?
No,
Or
that
Article
point,
8 as well?
There's another reservation, which your Lordship is entirely right. I do reserve my position about Article 6. This is because of Section 6. If my learned friend's argument is correct, that once the panel has decided to proceed, that is immunised from examination, the proportionality of that decision is immunised from examination, the scheme is not convention compliant. It's convention compliant if the county court, or possibly the judicial review court, but we would prefer to say the county court, can examine the proportionality of the review panel decision and the subsequent maintenance of possession proceedings by the council.
Well, it all depends on what sorry. It all depends on what one means by review. There's obviously a difference between Mr. Gravel and myself as to what the Strasbourg cases require by way of review. The way we put our case is to say, in each of the trio cases, McCann, Kosic and Paulich, the Strasbourg court has found no difficulty in accepting that the domestic law is convention compliant, and on our analysis has only required that there be a final asking of the proportionality question in the manner in which I formulated. Obviously, if we're wrong about that, we're wrong about that. But if that analysis of the case law is correct, in my submission there's nothing circular about it, that is what Article 8 requires according to Strasbourg. So the first factor that we'd say in looking at this question of exceptionality is the very important fact that Parliament has decided that the tenant should not have a right to challenge that the local authority has an absolute right to the property. The other factor that does need to be weighed in the balance always, of course, is that the Parliament has also enacted a safety net by way of the homelessness legislation and social security legislation, which will ameliorate, in some cases, in most cases, in some ways, the consequences of possession being obtained. And that's another factor which we say will always weigh in the balance.
Has Strasbourg referred to that?
Yes, it has.
Where's that?
I don't have that to hand, but in at least one of the cases, there is reference to the availability of social security. Although I must check that. Actually, I may be thinking of Lord Bingham in K, but perhaps I can get back to Lordship on that.
The trouble with that is that the people who have the most to lose by the eviction from their present home are, of course, the people who won't qualify as being in priority need under the homelessness legislation. So it will be a stronger measure against them than it will be against the people who are entitled to be not rehoused, but at least provided for under the homelessness legislation.
Well, that may well be true. It depends which. I mean, I'm addressing my arguments here, I should make clear, not just to the motor tenancy case, but to all cases where there's an absence of security of tenure. And often in those cases, they will be those who are most able to accede to that. I fully accept my lady's point that in some cases, they will not get the maximum support of the homeless legislation, although even those in priority need do have a range of support. And of course, it's Parliament who's decided how much different categories of people should get. So returning then to the two general factors I've mentioned, we then have the factors that we say would and would not count as exceptional in the ordinary run of cases. And as I've already indicated, our submission would be that it would be helpful for the Supreme Court to give some indication to the county courts as to what kinds of circumstances might be regarded as sufficiently exceptional to justify overriding the local authority's absolute rights under domestic law. Of course, such an indication can't be exhaustive, but we submit it would very easily provide a helpful calibration for county court judges in approaching the issue. we've put forward 3 examples of the kinds of case that might be sufficiently weighty. The examples we've given are where there's evidence which shows that there would be a serious detrimental effect on the mental or physical health of the occupant if they were to be evicted. The second example would be the terminally ill occupant very near the end of their life, where to evict them in that time would be disproportionate. A third example, in some ways this draws on the facts of Connors, would be a case where it could be shown, although how realistic this is one doesn't know, that there would be very detrimental impacts on children and the family, leading to divorce or children being taken into care. Those are the kinds of things that we've highlighted. In addition...
Those could all be wrapped up in the phrase exceptional hardship, couldn't they?
Yes, exceptional hardship.
And that is a phrase which is recognised in the legislation in this area as being ground for at least deferring possession.
Exceptional hardship might well be a useful phrase, although we would emphasise that it will always depend on the individual fact, and it will always need to be weighed against the local authorities' rights. Turning to the sort of factors which we would...
Sorry, can I just check?
Of course.
So I understand it. Supposing that... I mean, I don't suppose that these facts which you've got listed, these examples, to take one of them, person being likely to lead to complete family breakdowns. I don't suppose this would just come up for the first time in the court. So it would have been raised, I presume, in response to the notice, and it would have gone to the review committee. Now, they would have either accepted or rejected that. They might have said, well, we don't actually think that it will lead on the fact, we don't think it's going to lead to family breakdown. In that way, it's over-dramatic, it may do, but we don't think on balance, we don't think it's going to happen. Or they say, right, we understand that, but nonetheless, we're going ahead. Now, when that comes before the court, has that been immunised by the proceedings, or is that up for grabs again?
No. In my submission, that would be unrealistic for 2 reasons. First of all, one cannot avoid looking at the up-to-date circumstances of the individual if one is going to conduct an Article 8 proportionality exercise. The other point I would make is that that's a sort of comment that might sort of matter that might be raised, as it were, by way of mitigation or clemency in the review proceedings, but it wouldn't go to, for example, the antisocial behaviour which would form the reason for them. So it's in my submission a slightly different category. But turning...
So is the answer to the question then it can be re-examined? Even if the facts haven't changed at all?
Yes, if it's the personal circumstances of the individual which are said to... Then yes, sir. Apologise for not answering the question directly. Turning then to factors which we say would not ordinarily render the case so weighty or exceptional. Just to underline what we've already been saying, the first is that allegations of breach of tenancy or antisocial behaviour are disputed in or said to be insufficiently serious in circumstances where the statutory scheme doesn't require that the local authority prove them before a court. And that's really reiterating a point we've already made. Point 2, the fact that the occupier has lived in the premises for a very long time, we would say would be highly unlikely to weigh in the balance sufficiently. Point 3, the fact that the occupier has many local, family and social ties. Point 4.
Are these down in your printed case?
No, these are what we'll be producing for your Lordship tomorrow morning.
I see, thank you.
Okay. Point 4, the fact that without more, the occupier has poor health. Point 5, the fact that the occupier has young children. And the final one, and this is just drawn from an example that is raised in the Equality and Human Rights Commission's case, the fact that an occupier is someone who lives with the tenant, for example, as a carer, but is it not entitled under the legislation to succeed to the tenancy? All of those, we say, are extremely sympathetic circumstances, and one which inevitably one would have great sympathy to the occupier if they were facing in the face of those circumstances. But we would submit that for those sorts of factors to defeat a claim for possession would be to rewrite the choices which have been made by the democratically elected Parliament, because Parliament has not legislated that those sorts of factors ought to weigh in the balance, or at least to be decisive in the statutory schemes which ex hypothesi we're operating in, i.e. ones where the individual has no security of tenure, and nor is there any statutory requirement to show reasonableness.
I must say I have great difficulty with this proposition that we've got to look at what Parliament has said in this area. We're looking at the consequences of taking somebody's home away under Strasbourg jurisprudence.
But that's always against the background that Parliament has developed a very complex scheme of legislation, and the courts have developed a very complex body of the common law, which has defined very carefully the circumstances in which individuals are protected to greater and lesser extents against being evicted from their homes. And the classic example being the secure local authority tenancies, when one must prove before the county court one of a series of specified reasons, and moreover, one must satisfy the county court that it's reasonable to do so.
But this is no more than saying that's a good reason for saying that the requirements to satisfy Article 8, as it were, which you can invoke, or the court can invoke, or a tenant can invoke, are to be kept to a minimum to satisfy the Strasbourg jurisprudence. But they have to be the minimum. And as Lord Phillips says, I can't at the moment see why Parliament has set the bar higher or lower, or relevant factors or irrelevant factors, can play any part, because you've got to satisfy Strasbourg. And it seems to me that is the necessary and sufficient standard.
That must be right.
Yeah.
But
Parliament can't control what is the necessary and sufficient standard.
No, it can't. But Parliament is given a margin of appreciation by Strasbourg, as is clear from all the cases. And unless one has an exceptional case like Connors, the statutory scheme will lie within that margin of appreciation. And it's against the background of those important policy choices being made by Parliament as to balancing the individual rights of occupiers on the one hand and the important role of social landlords on the other in allocating houses, that the question must be addressed. Now, in the demoted tenancy case, introductory tenancy case, the various other cases which have been identified, there has been a deliberate decision that occupiers should have something less than the security of tenure that applies in other circumstances. And as I said, we approached on the basis that unless it's established that lies outside the margin of appreciation which the government has, that must be assumed in itself to be convention compliant. Strasbourg has, however, said in the recent cases that even in those cases, the proportionality of the measure should be capable of being challenged.
But once Strasbourg says that,
yes,
it's really detracting from Parliament's scheme to that extent. Yes. I just thought there'd be quite a strong argument for saying, well, then when you're going to see what's relevant to this, it's quite a good analogy to see what Parliament has said is material when you've got a secured tenancy.
Well, no, because you'll recall that Strasbourg has been very astute to emphasise that this is highly exceptional. It says so in McCann, it says so in Porlich. And the reason, in my submission, that Strasbourg has been at such pains to emphasise the exceptionality is because it's saying we accept that the domestic law may say the occupier has no right. All Article 8 requires is in the final analysis, the occupier must have one opportunity to say this would be so extreme, so disproportionate, that even weighing heavily the other matters, you should not evict me. And in my submission, that emerges quite clearly from the Strasbourg jurisprudence. So those are our submissions on exceptionality. Mr. Drabble says, well, it's not right to apply a test of exceptionality because that's a gloss on proportionality. And in my submission, one can put it in a number of ways. I would emphasise that the use of the word exceptional in K has been specifically adopted by Strasbourg, and so it must be taken to form part of their reasoning, and they're feeling comfortable with formulating the proportionality test in the way that they have. It may be that the better way of putting it is to say that given the weighty reason of the local authority's absolute right to possession, only an exceptionally serious hardship or something of that sort will be likely to outweigh it. But in my submission, we shouldn't shy away from exceptionality, whether put in that way or in the way the European Court uses it, and indeed to do so really would lead to the deleterious consequences that we say would flow from there being a free-for-all in the county courts, with every case turning into a merits hearing.
Does it amount to this, though, that in the case of demoted tenancy, there having been a decision that it would be disproportionate in the light of past conduct to deprive someone of possession, but proportionate to reduce them to demoted tenancy so that they're on good behaviour. Thereafter, it's entirely proportionate to have a scheme under which the local authority can, at will, say, now we want possession, without actually giving any reason based on conduct in particular. And the only defence to that would be, I'm sorry, we are terminally ill, or this would have a very detrimental effect on us, or we are seriously ill.
Well, is your Lordship putting to me that that's,
yes,
that's in practice?
isn't that the effect of what you're arguing? Because you said that there could be no proportionate examination of allegations of misbehaviour. That's all ruled out. So it amounts to saying that once you've got a demoted tenancy, the local authority doesn't actually have to give any reason related to the original decision to demote the tenancy or to conduct. It can give, simply decide that it wants the property, and you can't examine anything except some particularly serious personal illness or family consequence.
So subject to 2 points. The first being, whilst Parliament has made it clear that the local authority doesn't have to establish any particular reason, and doesn't certainly have to do so before a court, it has provided for the notice and review procedures. Admittedly, those are internal, the review is an internal review, because Parliament has decided that that's what appropriate, but there is that limitation on the operation of the scheme. The second point, of course, that one mustn't forget is that it's accepted that it may be in some cases there is a domestic public law challenge if a local authority is acting irrationally, and that is another remedy that may be available in extreme circumstances. But subject to those 2 points, in substance, I would accept the way my Lord puts it.
I just interrupt because it would help me preparing the reply to know whether the Secretary of State accepts that the review panel is judicially reviewable on the grounds that its decision is disproportionate and therefore breaches Section 6.1. In other words, is this an argument about forum, or is it an argument about substance that you can't, in any case, challenge the decision of the panel? And I simply don't know the answer to that, and it's important for my reply.
Our position on that would be that the decision of the review panel is impugnable on conventional public law grounds. It's only once the occupier has lost before the review panel and then has no right under the law to occupation, only at that stage that we accept the Strasbourg jurisprudence requires that there should be what we characterise as the long-stop proportionality test applied. Turning then to the difficulties with the appellant's position, and we see the way that they put it at paragraphs 18e and 25 of their printed case.
Paragraph numbers again, beg your pardon.
18e and 25.
Sorry, whose argument?
The appellant's, my lord.
18E.
18e. At 18e, they say, whether or not under domestic law a person's right of occupation has come to an end, the necessary procedural safeguards for ensuring that the extreme interference with the rights with respect to the home and conviction does not constitute violation of Article 8 are that an independent and impartial tribunal is available with the power to determine both whether the factual justification for the interference and the proportionality of that interference are made out. They then cite Connors and the other cases. I'll come to Zahentner in due course. And then we see a similar formulation at paragraph 25. It's submitted that the objection to allowing Article 8 offences on the basis that it would be difficult to attest to apply is not made out. First, the test for the county court would be clear. Are the reasons put forward as factual justification made out? And we make essentially 2 points about that. The first is that that goes beyond the recent line of Strasbourg jurisprudence for the reasons which I have sought to explain. Secondly, it is impossible to reconcile with Parliament's clear intention in enacting Section 143D of the 1996 Act. And the consequence of that, in my submission, would be tantamount to, or certainly close to, transforming non-secure demoted tenancies into secure tenancies. Because under secure tenancies, one has to make out in court the factual justification for a series of specified reasons, which include antisocial and unlawful behaviour. And one then asks the question whether it was reasonable. The question here is slightly different. Would it be proportionate? But in our submission, it really is to do violence to the statutory scheme that Parliament has enacted, and it can't stand with that. Nor, in my submission, can it stand with the Strasbourg Court's ruling in McCann that only in very exceptional cases will this type of proportionality review apply. Because if Mr. Drabble is right, in every contested demoted tenancy case, you will have a trial in the county court as to whether there was antisocial behaviour, how serious it was, and so forth. And one can test the point in a way by asking this: would local authorities bother to go through the process for demoted tenancies if the proportionality requirement is that put forward by Mr. Drabble? And in my submission, it's very difficult to see why they would do in circumstances where there's very little difference between what they would have to show in court after a tenancy had been demoted, never mind before it being demoted, to what they would have to show in a secure tenancy case.
Well, isn't it different, though? Because, I mean, you are starting several points down. It's the last straw principle would surely apply during a demoted tenancy. You wouldn't have to show very much against the background of its demotion.
The difference is purely what you're saying is that the gap is less than it would have been if it weren't for Article 8. But you can't say it's no different.
Well, in my submission, it becomes such a fine point of difference, really, that the advantage to the local authority in practical terms, i.e., once we've got our demotion order, they put a foot wrong, in our judgment, they're out. That's how demotion works. Subject to, we now say, is, as we call it, long stop proportionality argument. under my learned friend Mr. Drabbl's argument, get your demotion order, you decide they put a foot wrong, it's not in your judgment. The county court, you then have to go back to the county court for a full trial of whether they did put a foot wrong and how badly they put their foot wrong. It transforms the nature of the legislation and would become very, very onerous.
Well, we're now focusing on this particular area of the legislation, and it's a special area. All the objections you've been taking, presumably you couldn't raise at the demotion stage. There is going to be, is there not, at that stage, a trial of all these issues?
Absolutely.
And then the judge will have determined them. So that will be the background against which the events of the last year have to be judged.
Yeah.
And so the second stage, on any footing, is going to be very significantly less substantial than the first.
Well, with respect, we don't see that in circumstances where you'll have to have a further trial on the merits of any further matters that are relied upon. It goes from a one-trial process to a two-trial process. And that's a very significant difference in our submission. So we do say that the way the case is put on behalf of the appellants must go too far. It goes further than properly analysed the recent line of Strasbourg authorities require, and it goes further than can be reconciled with the quite careful balance that Parliament has struck in this field. And with that in mind, I turn briefly to the impact of the Strasbourg jurisprudence on the approach in the domestic cases. In a sense, I've already made my submissions on that, which is the second of my 5 submissions. In a sense, I've approached that in answer to questions from my Lord Hope about paragraph 55 of Doherty. But what we would say is this, that moving away from the demoted tenancy, strictly that scenario, in other cases where there's no security of tenure, what would be required in the county court is that the key facts on which the circumstances which are raised should be found and weighed up against the proportionality of the decision to seek possession, bearing in mind the local authorities' absolute right to the property and its legitimate aim in seeking it. And it would be done on an up-to-date basis, on the basis of the facts as they appear.
So these are the 3 points that I think you said were missing from 55.
Exactly.
So you're asking us to contemplate what the effect would be then on the way the courts conduct their business if you put these 3 points into the formula.
Well, the way it would work in my submission is that it could still fit within gateways A and B. So gateway A would be the Connors type situation where one had legislation which was incompatible with the convention. Gateway B would continue to include conventional judicial review, which has been accepted since Kay, but it would also include the McCann type of proportionality assessment, which would entitle and indeed require the county court to conduct that weighing up of the question of proportionality on the basis of any personal circumstances put forward. For the reasons I've already spelt out, we say that it would not be helpful or practical to seek to describe that kind of proportionality review as an aspect of conventional judicial review because of the 3 factors that I've outlined: the absence of focus on procedure, decision-making process, the timing point, and the nature of the test that is applied. So we would submit that the most simple and workable approach, if the court accepts our analysis of the Strasbourg cases, is to accept such a limited residual category of challenge, additional to and different from conventional judicial review, which involves the county court considering, in appropriate cases, when it is raised, a proportionality argument based on pressing individual circumstances, but bearing always in mind that such defence will succeed only very exceptionally given the local authorities' absolute right to possession in domestic law and important function in allocating social housing.
So is there a parallel or an analogy with the Norris approach there when you're thinking of exceptional individual circumstances, that kind of...
Yes, we did look briefly at Norris because I think my Lord Brown mentioned it yesterday. It seems to me there may be a parallel in this sense that I think it was my Lord Phillips who suggested in that case that rather than looking at it in terms of exceptionality per se, one should look at the test there as being, is there some exceptional hardship or some exceptionally serious reason which one would weigh against what would otherwise be the overriding factor, i.e., in this case, the local authorities' right to the property. So it may be there is a parallel to be drawn there, but we put the formulation based on really the formulation of the European Court of Human Rights in McCann, and say that really is the law that ought to be applied. That brings me to the third.
I mean, the authorities, they don't actually give very much guidance as to what precisely they have in mind by this concept in McCann of whatever the language was.
They're very exceptional.
Yes. I put a plea in docketed to ask them to explain themselves, and they haven't responded yet.
No.
I think they're still waiting.
Well, there seems to be a certain reluctance to dive into the water of exceptionality in Strasbourg, and indeed in the minority in K as well, recalling my Lord Walker's speech there and Lord Bingham's speech there. All I can say is we've had a stab at it. We do think that it would be useful to county courts for this to happen. And we do note that the formulation in Doherty has proved difficult to apply, not just in the county courts, but even in the Court of Appeal, where Doherty has fallen to be discussed a number of times, with various interpretations being put upon it. So all those factors in our submission do tend to suggest that seeking to give some guidance may be a helpful thing in this case.
Can I just understand, you said a moment ago that the county court would conduct this limited proportionality review of a McCann type. Are you departing from paragraph 60 to 68 of your case, which said that the forum from an Article 8 challenge had to be a separate application for judicial review in the administrative court?
No, certainly not, my Lord. That's the generality of non-secure cases.
So in this particular case, you say, because of the statutory scheme, it's got to be the administrative case?
In this case and the introductory tenancy case, and that's simply because Parliament has expressly excluded the county court's jurisdiction in this case. That's why it's exceptional.
Sorry, which paragraph in your case?
My Lord Mance was referring to it.
60 to 68.
60 to 68 was where, to be clear, because we're dealing here with a demoted tenancy case, we say that's an unusual non-secure case where one would have to go to the administrative court because the county court's jurisdiction is specifically limited and cut down by section 143D2 of the 1996 Act. So here, exceptionally, one would have to have that proportionality exercise undertaken in the administrative court.
I'm sorry, I thought you were adopting what Mr. Drabble said about section 71A of the...
I don't dissent with him in general on that. The only, 2 points I would make. In general, we accept that it can be brought in the county court. The exception is those statutory schemes, namely the demoted tenancy scheme and the introductory tenancy scheme, where the county court's jurisdiction is specifically limited to looking at the procedure. In relation to Section 7, I anticipate there's a separate argument that my Lord has in mind, which is the argument under Section 7, if we go back to the Human Rights Act, that Section 7(1)b requires that the occupant should be allowed to raise the argument in the county court. On that point, we do depart from, disagree with Mr. Drabble. What we say is that Section 7(1)b can be satisfied in the county court by the proceedings being adjourned pending an application to the administrative court.
And when it reaches the administrative court, is it conventional judicial review, or can the administrative court look at the Article 8 point?
Both, my Lord. So Gateway B, in its full glory, will be determined in the administrative court in this unusual case, normally in the county court. What that means is that wherever you are, you can bring a conventional judicial review, or you can rely on McCann, Paulich and Kosich and ask for the proportionality of the measure to be determined based on your individual circumstances. The only difference is here, because of Section 143(b)(2), one would unusually have to do that in the administrative court.
And that would be a judicial review of the decision of the local authority decision?
Yes.
To take the proceedings.
Yeah.
And you say exceptionally because in relation to secure tenants, the court's power to make orders for possession is expressed in the negative. Is that right?
No, for example, take homelessness accommodation, temporary homelessness accommodation, which is non-secure.
Yes.
There is no statutory
Yes, I see.
provision preventing a county court, limiting the county court's jurisdiction in relation to such cases.
Yes, I see.
So then one would just have it all determined in the county court.
And with secure tenants, it's mostly got to be reasonable to make an order, and that would incorporate Article 8 considerations
Absolutely,
anyway.
Lord, yes, absolutely.
How can the date point be accommodated in the administrative court? And the second component of the three was that you look as at the date when the issue is before the court, that is the issue for granting the possession order.
Yes, well, it would involve the administrative court doing exactly what the county court would do, and so hearing evidence up to date as to the personal circumstances and conducting the hearing in exactly the same way that the county court would normally do.
So what is it reviewing? Because I mean, it's not just reviewing the decision to bring the proceedings. And
As I say, it's both. If there's a conventional judicial review challenge, it's reviewing the decision of the local authority to seek possession, and it does so as it can do at the moment and does do at the moment. If there's also a proportionality challenge brought, then it's looking up to date at the position. It may have to hear evidence on the medical circumstances or something of that sort, and determines that challenge as at the date when it hears the application.
Proportionality of what, Mr. Stiddles?
The proportionality of granting of eviction.
But I mean, how can it? It's not judicially reviewing the proceedings in which.
No, but this isn't conventional judicial review.
I just don't know what it is.
that's the
Well,
problem.
it's what Strasbourg requires, and it's also pointed out to me that under Section 7(1), the person who claims that a public authority has acted or proposes to act in a way that would breach the Convention Act can be challenged. So there's no difficulty there in asking.
The mechanism is judicial review, isn't it? I mean, it's not conventional judicial review with a small c, but with a large c.
Yes. That's right, Will.
Well, I'm sorry, I mean, surely you can get the 7(1)b reliance on the non-compliance of the proposed eviction within 143(d)(2, can't you? I mean, you say you read 143(d)(2 as saying, forget 7(1)b. 7(1)b doesn't allow you to invoke this right in this legal proceeding. Why not?
Well, Because what section 143D2 does is really the essence of what demoted tenancies are about. Section 143D2 is saying once a tenancy has been demoted, the county court has a minimal role. The only thing the county court can look at once a tenancy has been demoted, if possession is sought, is it can check whether notice has been given in accordance with the procedures, and it can check whether there's been a review conducted in accordance with procedures. Beyond that, Parliament has ousted the jurisdiction or limited the jurisdiction of the county court. And that is the whole point with respect of the demoted tenancy scheme.
I absolutely see that, but surely subject always to 7.1b.
Well, in my submission, that would be going well beyond the interpretive obligation under Section 3.1 or Section 7.1b, because if you allowed that hearing to be conducted in the county court, our submission would be one would be directly going against the clear intention of Parliament in enacting that provision.
Because the jurisdiction of the county court is entirely statutory.
Yes.
Yes.
But the clear intention of Parliament in an act passed after a few years or 7 years after the Human Rights Act. 5 years.
Yeah. Well, yes, because there's no...
Because of care, I suppose.
There's no incompatibility. And I'm reminded that this is a point that's been examined extensively in relation to introductory tenancies in the cases of Manchester City Council and Cochrane, and in relation to McClellan and Bracknell Forest. And in both those cases, the Court of Appeal considered that it was a perfectly appropriate and sufficient means of bringing an Article 8 challenge to do so by way of a separate application to the administrative court, and indeed that it would be contrary to the scheme of the introductory tenancy scheme to allow that challenge to be brought in the county court. We can go to those cases if necessary. Cochrane, I'm reminded, is pre-HRA.
So we read 143D2 as saying the court mustn't make an order for possession, but must instead adjourn to the administrative court any application to rely on convention rights are made under 7.1b, and wait till that court's made a decision, and then, assuming the decision is favourable to the claimants, proceed under 143D2?
Yeah, if it's favourable to the claimants, dismiss, and if it's favourable to local authority, grant possession.
As long as nothing's happened in the interim, in which case you adjourn it again.
Well, there's always that difficulty, my Lord, in these cases.
Can I stop you there? You say that the reason, if they go to the administrative court, if they say it's ineffective, why would the county court still refuse an order for possession? It must make an order.
The proper analysis may well be that the effect of the administrative court's order will be to bring the possession proceedings to an end in any event. And so it would be unnecessary for the county court to make any further order.
The administrative court would be deciding that the procedure under sections 143E and F has not been lawfully followed, wouldn't it? That would be the effect of the administrative court's decision. If it had been lawfully followed, Article 8 compliant and everything else, they wouldn't quash it, it would stand.
Well, they would quash it because either it was Wensbury unreasonable under a conventional judicial review, or because it was disproportionate on an Article 8 challenge.
It hadn't been lawfully followed, effectively,
well,
in accordance with the totality of the English law. Otherwise, the administrative court wouldn't have jurisdiction to quash it. It can only quash it on grounds that are good in law.
Well, on grounds that the local authority had either acted unlawfully in public law or unlawfully under Article 8 too.
Unlawfully. Yeah. So, isn't it effectively what you are reading 143D2 as saying, therefore, as Mr. Drabble says, is the court must make an order for possession unless it thinks the procedure under second bar has not been lawfully followed?
No. I'm not accepting that. The approach would probably be that the
Unless somebody else, the administrative court says it hasn't been lawfully
well,
followed.
the administrative court would probably quash the review decision, and then the county court would have to dismiss the proceedings because the review wouldn't be followed. In my submission, I mean, I could come back to Cochrane, to McLennan tomorrow if needs be, because
because Cochrane was pre-Human Rights Act, and McLennan was very early days of the Human Rights Act, wasn't it? And it was when even Kazi hadn't happened by then. So maybe we will need to look at that.
And am I not right that we've got some cases coming up?
We certainly have.
Well, there've been further cases already. There's been Gilboy in the Court of Appeal, which is a case on demoted tenancies, which has held that the appropriate approach is to adjourn and for the administrative court to hear a judicial review application. So that's Court of Appeal authority for taking that approach. And my lady is right. There's also Howell and Hounslow, which is due to come.
That's what I was thinking.
To Supreme Court in November, which deals with introductory tenancies and homelessness.
Well, that's what I thought.
Yeah, we
so
have two others.
To be deciding this case on the basis of rather old Court of Appeal decisions about introductory tenancies is not the wisest way of resolving that.
The most up-to-date authority on this will be Gilboy. So perhaps I noticed we've just gone past 4. Perhaps tomorrow I can start my submissions by looking at those authorities so that the court can see how the Court of Appeal has dealt with this so far.
Are they in the bundle?
They are in the bundle. The authorities for your notes to look at on this are in order. Manchester City Council and Cochrane on introductory tenancies. McLennan and Bracknell Forest on introductory tenancies. And Gilboy and yes, it'll be the Crown on the application of McLennan.
Yes.
77.
And Gilboy is
Gilboy is at volume 8, tab 74.
and that deals with
demoted tenancies.
Thank you.
So perhaps that's an appropriate moment to.
The decision in K is pending at Strasbourg. Do you happen to know whether they're anticipating delivering it before the summer break?
I don't. We've caused inquiries to be made. A few months ago, we had some sort of indication that it might be imminent, but more recently we've had an indication that it's not. Not a very helpful answer on the table.
Very well.